And I will make a submission, my Lord, that that can never found a basis for establishing a case for a final order that there were threats at all. This is hearsay evidence, is not even admissible. So it continues. Over the weekend, information was obtained from various sources who confirmed that the second respondent made it clear that any property, including branded vehicles of the 7th and 8th applicants, will be vandalized and destroyed. Look how strong this bad language is. And somebody must come and defend this action. And somebody must say, all right, I now understand that there are various sources. How many of those sources there are, I don't know. Who they are, I don't know. Are they credible sources? I don't know. But they tell him, and as a hearsay evidence, that the property is going to be vandalized and it is going to be destroyed. Where? We don't know answers to those questions, and I ask them rhetorically because they are not in the papers. Now comes paragraph 71, that now is a concluding paragraph. Following an obvious interpretation of the facts and conduct by the first to third respondent, a local newspaper city press published something. Let us talk about that, my Lord. The day newspapers are able to pronounce in on legal concepts with authority. I will leave practice. It is their own interpretation. What angle they come from, they are not telling us. What inspired their opinions on the matter doesn't tell them. But they are not entitled to give a legal opinion in respect of a matter about which this court is seized. That they are not entitled to do. Whether they share that opinion together with the applicants is an irrelevance. Ultimately, your Lordship must be persuaded that the language used, however interpreted, in whatever context, constitutes the hate speech or xenophobia, as my name according to the want to have us believe. Well, let's go to the beginning of the affidavit and go see whether we're going to find any evidence of a threat. The application starts from paragraph 34 in relation to this issue. On Thursday, 4th February 2016, says paragraph 34, the first respondent appeared on national TV via a press conference hosted by the second respondent, at which the first respondent, Malema, lashed out at the Gupta brothers and their commercial interests with a clear and unambiguous threat of violence and xenophobia. But Mr. Malika says, I've never said anything about Indians. I'm talking about these words. How can it be xenophobic if you dislike a particular person, whatever his nationality or race? How can that constitute xenophobia? Are they able to support this conclusion that they're making in the papers? The answer is no. Now, if this interdict must rest on the basis that Mr. Malema is xenophobic, simply because he says, I don't like the Guptas with what they're doing with our country and our politics, then, my Lord, we are on a very slippery slope. Very slippery slope for the democracy that we say is robust, must take these things on the chin and understand that that's the nature of democratic discourse. No, but they say it is very clear that if you say to somebody they should leave the country, it's a threat of violence. How can that be true? How can that ever be correct? That to ask somebody to leave the country is a threat of violence. So why? But I'm going to examine the other things because I'm told if you use the word eject, then you must be connoting a violent conduct. But that's not true. Your Lordship will see a dictionary definition of evict has several meanings to it, including to remove. What is violent about that? You eject a cartridge from your firearm, what is violent about that? You eject a pilot in case of emergency, what is violent about that? That's also English, that's also grammar. So why do you go for one interpretation and try to paint Totally to the other extreme, a particular use of a language. As we know, words mean what they do, and they mean what they do when they are read in context and within a particular circumstance. Now, they say it's unambiguous. I don't see how they should leave the country unambiguously means violence or a threat to violence. But I'll examine what my learned colleague said. We must read into it. Comes paragraph 35. The press conference was held about 1200 hours, and a recorded version is not only available on YouTube, on the internet, but I will also ensure that a USB device containing the press conference is made available to the Honorable Court, from which the threats of the first respondents are clear. Again, they just used the word threats. These threats were aggressive. Leave the country. What's aggression? What's aggressive about that? This is a political organization that is campaigning for votes and saying one of the ills of our political climate is the relationship these people bring to our political landscape. We want them to leave. Surely that must be a fair comment in a political landscape to make that assertion and to make it boldly for that matter. They are repeated and inciting. How can that ever be inciting? Your Lordship and I would know that we come from all forms of political expression in this country. The votes must fall, Zuma must fall, this and the other must go. How does that constitute violence or the threat of violence? In fact, in exhibits X6 or X5, I mean the president is called a president, a rapist, a thief. Are these words that are inciting violence? That are uttered in a placard by a political grouping that is seeking to solicit, whether rightly or wrongly, support for their ideological positions. That is proper politics. How can that be incitement of violence? But I also find that I am almost groping in the dark. And I'm groping in the dark because there is no evidentiary basis for these words of repeated inciting aggressive threats of violence. Nothing. They go on to page, on paragraph 36. Amongst others, first respondent promoted violence against the group that gathers and any commercial interest held by them by stating that they should leave the country and that South Africa is not for sale over a plate of curry. Just imagine, a head of a political organization, I think the third largest party in the country, says our country is not here for the plate of curry. This incites violence. In fact, the Lordship would have seen in the Sunday papers, the past Sunday paper, the Sunday Times had a cartoon of Zapiro, which says the president is a lapdog and the president saying the Guptas are the president. That's in the nature of these type of things. This is in the nature of the political space. These are things that must happen in a democratic dispensation, and they must be welcome. And the judgments are also clear. You don't condemn a speech simply because you don't like it, or you think it is offensive. Otherwise, if you go down that direction, the freedom of expression is gone from the drain. Our judgments are very clear there. So all they're saying is, we don't like you thinking that we are buying the country for a plate of curry. I'll be surprised if this would even provoke any sense of agitation in my children or anybody for that matter. But again, I'm groping in the dark. Where is the violence implicated in this? And where is somebody being enjoined to go and cause harm either to the Guptas or to their property, simply because Julius Malema, the second respondent, or the first respondent, believes strongly that his ideological party position is to advance this. If he's said, I want nationalization of all South Africans, or I want XYZ to be our socio-economic platform. That's what he's campaigning for. The horror becomes when he gets the majority that gives the mandate to bring it back. But we can't stop him from saying it. Not in a constitutional democracy, not in a state. But I'm examining this. The first respondent further stated that the Gupta brothers and all their business, directly or indirectly, will be removed from South Africa by whatever means. He was clear on this point. Unless they intend to insult South African populace, that anybody who hears this, they're going to be removed from South Africa, and you say why? Because in those articles, it's not something in space. It is something about an entity or people who are associated with the head of state, and everybody complains on that point in the public space that this relationship is unsavory. And another political party here says, it is unsavory, we want them out of this country if we are to protect this country. And that may very well explain why they get the votes, not why they attack the voters. But where do I find a connection between any conduct that has been provoked by these statements on the part of any of the followers of the EFF? The first respondent accused the 7th and 8th applicants of being a cartel. Well, with respect, my Lord, surely this court is not going to be determining whether there is substance or no substance to that accusation. It may very well be that it does have. It may very well be that all of these accusations about criminal concept and this and the other will one day, in a proper forum, be ventilated and found to be meritorious or lacking in merit at all. But this is not the business that this agent court is invited to investigate. Then we are told it is further of imperative importance to mention that the first respondent mentioned and made it clear that he could not guarantee the safety of any of the applicants. How can there be ever an incitement of violence? The leader of a political party properly registered in an election, in a campaign on an election year says, I'm not going to guarantee your safety, your sorry. Guarantee the safety of any of the applicants or even any of the employees employed by any of the applicants. Why do you hold that to constitute an incitement of violence? Particularly, as I must reiterate, my Lord, we're not talking about Joso and Joso having an exchange as ordinary colleagues who then go a little way this direction or a little way that other direction. We're talking about a constitutional right to campaign and to contrast yourself with other players. And there is no doubt that the party with the majority in this country, the African National Congress, they're the leading party in government. All opposition parties have as their primary motive to unseat them. So if you can identify any weakness, whether right or wrong, and you consider it a weakness enough to vote away the voters to yourself and from them, and you want a court interdict because there is a threat of violence with respect, we can't be going down that road. Paragraph 40, in an effort to engage with the respondents, the applicant, through the 7th applicant, TMA, should issue press statements expressing its concern about the threat of imminent violence. Now, this is following a statement of President IV, when they're dealing with imminent violence. And now we know this imminent violence was supposed to happen on the 9th. Well, there's no evidence of any of these statements. It's just concluding remarks, concluding statements, evaluative statements with no evidentiary underpinning. And it's very difficult to defend against broad assertions which are made in this style. And worse off, which I even hear say, and worse off, where there is no support for anybody who can vouch to the veracity of those statements. Now, to the extent that there was any ambiguity about what the EFF was saying or what Mr. Malema was saying, he clarifies that statement and says, I am not talking about violence. You would think that would ameliorate their anxiety. No, it doesn't. On the contrary, they call it a backtrack. And they persist with the fact that it is inciting violence. You can, my Lord, with respect, go to paragraph 45 as well. You will see again is to create a climate to execute violent threats, threatening the property and the persons of the applicants and their employees. What are these threats? I say they must go. I asked it rhetorically again, my Lord, to make the point. Nothing in these papers tells us, you, Mr. So-and-so, you got into a car on a particular day and you threatened me by driving it against the wall, or you took a firearm and you did this, or nothing, which is evidence of the threat that they are complaining is being cited. Nothing is being shown as evidence that as a result of this behavior, we see a number of violent activities happening at this or that place, and the only connection to that violence must be the utterances of A, which are the incitement for the violence. There's no connection at all. Again, in 46, they quote Annexure B. It is the same statement, conclusory in nature, without any evidentiary basis or support for it. In short, we are going to physically drive the Zulkas out of our province. Because they want to win the Gauteng province, they have to make that type of statement if they honestly believe it will advance their political cause.
Which paragraph were you reading from there?
I'm reading from paragraph 47 of the report.
Yes.
This is a man who has come on record to say they are going to win Gauteng as a province. And he's saying to people of Gauteng, I'm going to make sure that I drive these people out of this province. They're not going to be able to do these things. Fair comment in political landscape. Absolute fair comment. Why does it provoke an agent called Interdict? We will mobilize all our branches. Of course, that's how we win your votes. Especially in Ekhuleni, we know there's a metro that is contested. Johannesburg is a metro that is contested. Tshwane is a metro that is contested. And with the DA and all political opposition parties predicting that they will take it away from the ruling party. All of this is fair comment. Now they come to court and invite your lordship under a democratic order. Restrain these people. They mustn't go and tell the electorate there that one of the things they want to achieve is to have a corrupt-free province because they know from a premise that the whole relationship between the Guptas and the president will be corrupt. What's so wrong about it? Now, they say this is an unequivocal and clear message. The respondent intend to use their members and their resources to destroy the businesses of the applicants and will stop by no means to violently prevent the applicants from conducting this business on a day-to-day basis. Where's the evidence for that? They are indicating to your lordship not one incident, that In our attempt to do ABC or to go to work on this day, we were followed by 3 cars which we couldn't identify, and we can only connect it to the utterances which have been made by this political party against us as individuals and against our assets that are in the country. You think that it improved on it, if you look at 49, it doesn't get better. Not only are these threats imminent and calling on violence, but the further infringes on the African's constitutional right, with which I will deal later in this affidavit. My learned colleague says, anytime somebody says they cannot guarantee your safety, they must mean that somebody must be violent against you. That's too hard a proposition to make, particularly coming out of a mouth of a politician on an election year, campaigning for these votes. And we say, no, they're not going to be saying these things. We are going to court and we're going to ask the court to stop them from doing this. So they mustn't go tell the electorate, we want to get housing, we want to get we want to get Swani, and the way we are going to do it is we promise you now, we're going to get rid of this corrupt relationship, of this influence. That's the community practice. I believe it, maybe I don't. Do I believe it? Maybe I do, but that's irrelevant. That's in the nature of the beast of being in the political debate and space. The other place where you find this imminent violence, it is paragraph 55. It is further obvious that the second respondent refused to withdraw any of the comments or threats made by the first respondent at this press conference referred to earlier, or the further threat of imminent violence. What imminent violence are there, we ask? There's no answer to it. Your logic is not pointed to any evidence. And we can scour each and every paragraph in the form of paper number. Absolutely no evidence is offered apart from the utterances of a political party at a press conference which is intended to be an electioneering campaign, that there is any possibility of harm to the applicants or the companies. Well, I haven't been able to find any snittle of evidence that supports the conclusions that they're making. But again, my Lord, as I go to my third area of address, the applicants are seeking a final vote. And as our case law would tell us, that's only possible if that order can be supported by what we say in our reply, and such fact as they allege to which we as respondents admit. We're not admitting any of this. There's a sharp dispute of fact even about whether or not there is ever a violent threat. But, my Lord, in the answering affidavit, your Lordship finds a very strong statement to which they don't respond in reply. It says, the EFF is not known for violent protests at all. So you can never even harbor a suspicion that this one that is going to happen at a constitutional court will be violent. And as a matter of fact, has proved it was never violent. Now let us look at the type of relief we are seeking against that program. They say we must stop from repeating previous threats. Okay? I mustn't say as a head of the political organization, I want the Bukas to leave. Because saying that it's a violent threat, it incites violence. That's saying the Lordship must tell the respondents that if you ever again say you are going to be evicted, then they will be guilty of a court order and liable, amongst others, to a number of legal consequences for the matter. That's prayer 2.1, right? Interfering with activities of any journalist employed. Now this can be in right English. Any activities, what type of a court order is that? In particular, interdicted from any conduct or making or promoting any remarks, preventing any journalist hand at political campaigning so that you can improve the opportunities for people who are your friends. Because that's the effect of this. Malema can say, please, I want you out, or the country is not for sale at the gate of the country. No. The breadth of even that relief is just not competent. Inciting imminent violence against the applicants. How does this relief work? You go to the police station and say, there is a court order against Malema not to incite imminent violence. He has incited imminent violence and therefore is in contempt of a court order. I've never seen anything like this. The interdict must be against a specific conduct that is identifiable, that is clear. Don't assault. If there is an assault, then we know you are in breach. You can't be in breach of inciting something that is imminent, causing damage. Now, where in the papers have they said we have caused any damage or threatened to cause any damage except to say they must take their things and go? Entering or threatening to incite its followers. How does this work, my Lord? Do you go and say, there he comes. He's going to be inciting some people of my followers, therefore I'm going to stop as a security guard. But those people are working there as South African citizens. They are entitled to participate in the political discourse of this country. And if Malema wants to go and canvass their vote, he's entitled to do it. But no, says the applicant, you, my Lord, as a court, must stop that activity happening. How is this ever a democracy if we are ever contending for? Promoting or maintaining any conduct which could reasonably intimidate any of the applicants. I've never seen anything like this as an error of court interdiction. Promoting infringement of the 7th and 8th applicants' right to freedom of expression. Can one promote an infringement of the freedom of expression? English, I confess, is not my first language, but I don't even understand what it is. Participating in any conduct or promote the removal of any of the applicants from Gauteng or the Republic of South Africa. How is this possible, my Lord? This is a permanent interdict going to go into the sun about somebody who's been accused of all sorts of criminal conduct and impropriety. But they're asking the Lordship to give a final order today in perpetuity that will say, you can never promote, even if there is a lawful basis for achieving it. So says this court. You can never participate in any conduct to promote his removal. Even where lawful causes don't exist, what type of interdict is this? Well, the prayer 3 relates to the court respondent. And we make a point about that no agency has been shown, particularly of the nature that has occupied us since 9 o'clock this morning. And now that we have argued in full, we submit that the proper order to be made is one of dismissing the application. So in conclusion, my Lord, no evidence has been made. They don't belong into this court. This is an abuse of the court process. If they have made out a case for agency, we say there is absolutely no evidence of any conduct on the part of the first three respondents that indicated they want to act violent against the applicants or they're inciting anybody to act violent for them. There is no evidence of that as an indication. 3, all these threats that they were receiving, so many calls at night and so many missed calls and what have you, absolute hearsay. We are not told who those people are, when those calls were made, by whom were they made, what was the nature of the threat, did it relate to them as person, did it relate to them as family, did it relate to them as South Africans? We don't know. And yet they are asking for a final interdict. West. One of those are submissions to ask for the application dismissed and dismissed with cause.
Thank you, Mr. Semenya. Mr. Moritz?
I'll really truncate the answer if you want to give me.
Yes, thank you.
My Lord, might I just say, and if necessary, we'll give the Lordship the affidavit. We've got live feed here telling us what's happening at the march. He says, the march is over, nothing happened. Well, it's not on the papers. Let me tell you that he's wrong. But the press report says the people are singing. Another song went, shoot Zuma, shoot the Guptas. This is the EFF singing a song this afternoon while we argue. Shoot Zuma, shoot the Guptas, with Mr. Malema there with him. That's what the press is reporting at the moment. So we'll put that on affidavit and give it to your Lordship with a copy of that article. That's what's happening at the moment. My learned friend wants to say nothing's happening. That's what's happening. My Lord, with the greatest respect to my learned friend, he totally disregarded the requirements for an interdict. He scrambled everything together as though it's all one thing. Let's start at the beginning. Interdicts 101, as they say if you go to university. The first requirement is a clear right. Does the applicant, or do the applicants have a clear right not to be threatened or intimidated? No scope for debate. Obviously they have a clear right. The question is, was that right infringed? Of course, my learned friend was incapable of contending that that right was Gupta's. The incitement to violence ongoing. Lord, with respect, important to realize that this is not a defamation interdict. My learned friend, almost every answer he gave was, this is political debate. You're allowed to engage in mudslinging in a political debate. The issue here is not whether you say the Guptas are corrupt or the Guptas are getting unfair favors from the president or the Guptas are breaking the rules. That's not what this interdict is about. We're going to physically drive them out of the country. And they better take their things and run from the closest airport, or else the outcome against their person and property is predictable and will be volatile. And with respect to that heading, I emphasize what happened since the threats. Learned friend says, but what's happened since the threats? The threats, of course, in the television interview and in the press statement of the 6th of February, what happened since then? Well, we've seen the placards. We're going to fight war with war, that's today. Guptas must go. The song being sung, shoot Zuma, shoot the Guptas. Now, is there a reasonable apprehension that when the leader of the EFF is there where this is happening, undisputed, that there's no reasonable apprehension that someone may lose their head in the red uniform and the red beret, and as a group start engaging in violent conduct against the Guptas and their interests. The learned friend had much to say about paragraph 71. He pops off things and he says, but this is hearsay. But the reason is because he takes one line, he doesn't look at where it comes from. Paragraph 71. There's a quote from the City Press article. And he said, but this is all hearsay. Since when can the press say what the outcome is going to be? Since when can the press say what the outcome is going to be of the Constitutional Court? But paragraph 71 refers to F. It's not the press that says this. This is Mr. Malema who said it. He's been quoted. Page 54, which is Annex F, is in fact quoting the answer of Mr. Malema to the question. So it's not the press saying it, it's Mr. Malema who's saying it. Look at page 54. Zuma needs to apologize to us all. The EFF's Julius Malema tells Stembili Chedi and Ferial Hafaji that he's demanding that the president do far more than pay back the money. And then, first paragraph ends with the word, City Press spoke to party leader Julius Malema at EFF headquarters in Johannesburg. Then in bold you have the question every time, you have Mr. Malema's answer. On the right-hand side, what kind of beat will this be? That's the question by City Press. Mr. Malema's answer is quoted. We are going to win in the Constitutional Court. Since when can a leader of a political party with no legal qualification have the temerity to say in advance of an argument that the case was going to happen? As my learned friend himself said. And there is going to be a nice surprise party for the Guptas on Tuesday. And in Parliament we're going to come and challenge the President and the white shirts, etc. Mr. Malema's words. My learned friend apparently didn't even realize that the article purports to quote Malema. What's important, my Lord, is that it doesn't help for my learned friend we submit to say there's been no actual violence. No one has yet been violently thrown around, assaulted. Nothing's been burnt. Nothing's been broken down. Therefore, you can't get an interdict. The interdict is not sought at interdict from continuing to assault or continuing to burn or continuing to destroy. We say you must not engage in threats and incitement to violence. Because with respect, one has a right not to be assaulted, not to have one's property destroyed. But one also has a right not to be threatened with assault or with the destruction of property. And that's really what this case is about. So my Lord, it doesn't help to come with a refrain, but everything he said is fair comment. One reads Annex B, page 46, as a whole in its context. And there's no answer whatsoever which can be raised, and none has been raised, that read as a whole, this was a call to physical action against the Guptas and their interests and their physical, forcible removal from the country. As you also please. Those are some.
Thank you, Mr. Moritz. I've listened to the arguments of counsel for the applicants and the respondents. I think it's important that I give the answer now without giving reasons. Those I will give later as soon as possible. What I intend doing is making an order and then giving the reasons subsequently. Mr. Moritz has suggested certain amendments to the order originally sought by the applicants, and I have appended those amendments on the notice of motion. An order is therefore granted in terms of paragraphs 2, 3, 4 and 5 of the notice of motion, as amended. And as I've indicated, I shall give the reasons as soon as possible. The court adjourns.
You must appreciate that the urgent application also requested the judge to assist and protect the employees of the Gupta family and their interests commercially in Gauteng. I've said earlier that there are about 4,000 employees. This order prevents the respondents from entering a premises, damaging any assets, damaging any of the equipment of the applicants, or to damage or harm any of the employees.